Today, I would like to discuss 4 documents that almost every homeowner, potential seller, needs to sign before signing a contract by selling their residential home. What I'm saying almost is because there is one document that we will get to it shortly, that's the lead paint document, that not everybody needs to sign. But pretty much the majority of people, when they sell a home, a single family, multifamily, condo, co-op, you name it, a residential real estate transaction, they need to sign these 4 documents, and I would like to go them over and give a very clear understanding for everybody what these 4 documents are. So the first document is what we call a listing agreement. It's pretty much how the document looks like. Over here is the owner's name, whoever owns the home, and we write in the address of the property. The next line over here give you is the real estate agent you hire. The real estate agent's name go over here. Basically say we give you permission to help us sell the property for X and X amount of money, whatever the amount is, and for how long that agreement is in place, from date until date. This box then talks about on what date this property will be available for the public for viewings. So for instance, if you sign an agreement with a real estate agent today for the next 6 months, 8 months, or whatever you agree on, it doesn't mean it's available tomorrow to be shown to the public. There's a separate date that the homeowner and the real estate agent will come up with when the property is being made available to the public. That's that line. Over here is the compensation, is basically the commission the homeowner agrees to pay to the listing agent, and how much a listing agent would pay out to a buyer's agent if there is another agent who brings the buyer into the transaction. The next paragraph talks about commission earned and owner's obligations after the expiration, termination of agreement. Some real estate agents will put in over here, let's say, if within whatever amount of days, 30, 60, 90 days, that even if that listing expired, let's say on January 1st, 2024, just to put a date in context, and within 3 months later, you still get some sort of buyer, reach out to you, they know the home was on the market, you took it off, you didn't sell it, and if you have that clause filled in, let's say 30 days, if by February somebody still reaches out to you, you still own commission to that agent. It's something you want to pay very close attention to make sure you're comfortable with that. And obviously, it's between the homeowner and the real estate agent to agree for what time period the homeowner will be responsible to pay a commission to the real estate company. That talks about marketing. The owner grants to the listing broker full, basically, discretion and determine the appropriate marketing approach for the property. Obviously, whoever you hire, you want them to have a solid plan, aggressive, and to today's market, obviously, not just some old school tactics. Yeah, so obviously the owner grants to the listing broker full permission to promote their property. Then there's an option if the owner agrees to put a for sale sign out in front of the house. If the owner obviously agrees to have a lockbox by their door so the agent can easily come and go and have access to the property. And one thing I want to point out is, it's not that when you put a lockbox that people can just come and go. Everything is being worked, and if the home is occupied, every appointment will need to be approved by the homeowner through obviously a very easily text messaging system, which is called showing time. So let's say if I want to show your home tomorrow 4 o'clock, I put in the request, let's say right now, and you, the homeowner, will get a text that says somebody requested an appointment to see your home tomorrow 4 to 4:30. You can reply yes or no. It's that simple, that easy. So there is no confusion, and everybody knows if the appointment is approved or not. When that appointment takes place, we can still see what time the agent went into the house, what time they came out everything obviously connected with technology makes the process easier and safer for the homeowners. Rental of property, if you agree to let it rent out, then you need to fill this out. Then you need to fill this paragraph out. This paragraph talks of use of audio recording devices. So we have to disclose and let the owners know that it's a violation of New York State penal law to overhear a conversation by having any device, any sort of recording devices in the home. So we need to check this box up if it has or if it doesn't have any recording devices in the house. The additional points line, if the owner and the real estate agent agree to any other terms between them. All modifications to be made in writing, obviously. You don't want somebody to say, hey, I said this. Everything should be made in writing, preferably by email. Maintenance of property, obviously, is the homeowner's responsibility. Home equity theft protection. Obviously, we recommend every homeowner that if you have any electronics, jewelry, you name it, keep it somewhere safe, in a locked closet, if you have a safe in home. If you don't, there's very easy to get a safe deposit box in any of the local banks. Escrow and recovery fees doesn't really require for us here in Westchester, because in New York State, real estate agents don't hold the down payment that a buyer, potential buyer, will bring towards signing the contract of your house. So when a buyer signs a contract, there is a down payment they will be putting down towards the purchase of the house. In New York State, it goes to the attorneys. It's really not something the real estate agents hold or get involved with. So all of these things don't really require for New York. Property condition disclosure does not apply to New York either. Let's say if there's anything in the property that's really wrong and you know about, in other states, you need to disclose and provide some disclosure documents about them. In New York State, it's very easy about that. And by the closing, every homeowner provides a $500 credit to the buyer, that just in case there's something they didn't disclose, this is $500 credit, and we don't owe you any disclosures. That's just New York State. Copyright notice basically talks about all the photos, all the marketing material that the listing agent does belongs to him. There's a copyright notice on it. Acknowledgement, that the owner read this through and understands this whole agreement. Equal opportunity in housing is that we have to make it very clear with the homeowners that we cannot discriminate against anybody, color, race, you name it. There's a separate document about that, which is one of the 4 documents that we will get to shortly as well. Pretty much the homeowner sign here, the listing agent and listing broker sign over here, and that's your listing agreement. That's document number 1. I hope that gave you a pretty good understanding and a view of that document. I'll show it to you again once more, so you get to see what the document looks like. It's very standard, nothing tricky or complicated over here. There's a lot of clauses in here that does not apply for us here in Westchester, but it's just in here because it's a standard document. That's something that can easily be erased. The second document we have over here will be, the lead paint disclosure. So lead paint disclosures only need to be signed for homes built prior to 1978. Prior to 1978, the paint that were used in the homes had a lot of dangerous and health risk materials within it. And we have to make a disclosure to the buyer. The seller needs to sign and the buyer needs to acknowledge, and the agents need to sign as well. So if the seller knows about the home having lead paint, they tested it, or you name it, then they have to check off the first box and say, yes, we do have, and then we have to provide the buyer the documents. That's something we have to disclose in New York State. The seller has never tested it and he has no knowledge of lead-based paint in the home, we just check off this. The second box over here talks about that if you ever did test it and you do know that you have to provide the purchaser with all available records. Over here, the purchaser acknowledged accordingly. If they did receive copies or they didn't receive, they were given opportunity to test, or they waived the inspection. Most people waive these inspections because lead paint, from what I understand from experts in the industry, it only gets dangerous when you start playing around with it. agent's acknowledgement, and again, the seller signs, purchaser signs, and the agent signs. That's document number 2. For new constructions, homes built after 1978, that doesn't apply because these paints were not used anymore. The third document you have to sign is the disclosure form. This disclosure form has a lot of different categories. Let's take it one by one. And by the way, all these documents, they're not really contracts. This is New York State required documents to get you moving with the real estate transaction. So the first one is, this is a disclosure form for buyers and sellers. So there's a couple of different scenarios here that could be. There could be someone who's a seller's agent, right? You hire somebody that will help you sell your property. This is a seller's agent, a listing agent. They are being hired for the best interest of the sellers to help the sellers sell their home for the best price, best terms, have the sellers back by all times. Then there is a buyer's agent. If there's an agent who has a buyer that makes a good offer on your property and you want to accept that offer, that buyer's agent will need to have a disclosure form with the buyer. This has nothing to do with the seller. So the seller's agent, so if you are the homeowner selling the home, you will need to check off that you hired them as a seller's agent. The buyer's agent, when they work with a buyer, they will need to check off buyer's agent. Then there is broker's agent. Broker's agent basically means, let's say there's a real estate broker that has a client and that broker does not have time to show the property to his buyer for whatever reason, he's busy, and he has a showing agent that goes out and and shows the property for his client. They need to check off on broker's agent, because the person who shows it is not the buyer's agent. He or she is the broker's agent. It is somebody else that the client has a relationship with, and they have the relationship with the broker. There's just somebody who comes and opens them the door and shows them the home. That's a broker's agent. Then there is a dual agent. Let's say the listing agent did such a good job, they got a direct buyer for the property. There needs to be an acknowledgement between the homeowner and the buyer that there's one agent representing them. This is dual agent. Then you check off seller's agent and dual agent. There's a dual agent with designated sales agents. Let's say some homeowners will say, yep, I understand you did a great job, you got a buyer for my property, I don't want you to represent the buyer. What you could do at that time is, you can bring in another agent from your firm, and you make that agent the designated agent for the buyers. That's dual agent with designated sales agent. So you don't talk. So the listing agent won't talk to the buyers, and the buyers will only talk to that new designated agent over here. That's pretty much that document. Owners sign here, and that's that disclosure. Then we have the New York State Housing Discrimination Disclosure. So that very clearly discloses the purpose of this. Federal, state, local fair housing laws provides comprehensive protections from discrimination in housing. It is unlawful for any property owner, landlord, property manager, other person who sells, rents, or leases housing to discriminate based on certain protected characteristics, which includes but are not limited, and the state goes on to name some of them. The bottom line is that we have to make that disclosure to sellers. There's a lot of other things that real estate agents need to hold to, and you can very clearly see them over here. You're not allowed to stare, you're not allowed to blockbust. There's a lot of different things a real estate professional is being held accountable to, and we provide a list of some of these important items to the homeowners. We also tell them that they have the right to file a claim. If you feel you have been discriminated by a certain agent or anybody, there's a website where you can report the real estate agent. There's a hotline number, and that's basically a disclosure form that we give the homeowners or buyers, whoever you work with, to sign. So they sign basically that we disclose to you about all these discrimination, about the discrimination disclosure form. I hope that helps. These are the 4 common documents that every homeowner, when they sell a home, will most likely go through. After that, the next most important document will be the contract of sale. is a whole separate, I would say, is a whole separate conversation. In general, I will say something that in a New York State contract that's different from New York versus other states. In New York State, the typical language in a contract will say the closing will take place on or about, let's say, January 15. That doesn't necessarily mean it will happen on January 15. That basically means that within these 30 days, that means up till February 15, the closing will take place, depending on how the two parties will move along the process. The mortgage has to get ready, the seller needs to move out if the home is occupied. There's a lot of things that need to come in place, obviously, right? In other states, if you put a date of January 15, that means you're going to close on January 15. In New York State, it means on or about, you got about 30 days. Another important factor in a New York State contract is the mortgage commitment time. So, in general, let's say if you sign a contract today, one of the important items to pay attention on a contract is the commitment period. So, you sign a contract, the buyers usually sign first, then the seller signs. The buyers will give down payment to the seller's attorney, and then you are legally in contract. Once that happens, the buyer, if it's a mortgage, the contract will go to the mortgage company. The mortgage company will start working on their file. Obviously, they haven't pre-approved before, but now it really gets into real motion where everything has to get moving into real facts. So there is a period of time in the contract that's called the mortgage commitment period that the buyers have to obtain the mortgage. Sometimes it's 30 days, sometimes it's 45 days, depends what the two attorneys, seller, buyer agree on. And sometimes it comes after that time, 30 days, 45 days, the buyer doesn't have the commitment. And the buyer's attorney will reach out to the seller's attorney and say, hey, look, I know what the delay is. It's that specific item. I know we're going to be able to solve it in 5 days, 10 days. And the seller's attorney, with the seller's permission, will give them an extension. And then they have another 10 days to obtain their commitment. Usually when you have the commitment is when you pretty much get to figure out your real closing date. Because this is when you get really close. It could be somewhere between 5 days, 10 days, 3 weeks. Anyway, from when you have the commitment until you close, things move pretty quickly. Depends obviously on how quick the buyer and the seller want to move it. Another important factor in New York State contracts is we don't have a clause of inspection. So inspections over here are being done before you sign a contract. In other states, you have a clause, a period of time. You sign contract today, you got 10 days to do inspection, then you come back out. So that's something we don't do in New York State. What else is important in New York State contracts? I'm trying to think if anything specific. We don't have contracts contingent on inspection in normal circumstances. We have mortgage commitment periods, and the buyer signs first, sends a down payment to the seller's attorney, and then the seller sign. I think that's pretty much the most important items about a contract. Obviously, in every contract there will be things like in the home that a seller will say, oh, this is included, this is not included. Usually things that are built into the house stay in the home. Other items the seller can take them out or say, you know what, I'm giving them along the way with the sale of the home. But it depends. Every seller has different things that different reasons why they move and where they move, and they might not need something. So everything is being worked out in the contract. So this stays in the home, this we take, and so on and so forth. It's very important to have a real estate attorney that will work along well with you and obviously try to protect you. If you have any questions about any of these documents, feel free to call me, email me. I'll be happy to explain you and answer any questions you might have about those. Thank you for watching. Have a great day.